The prosecutor struck every single black juror. Not one remained. James Batson, a black man in Kentucky, now faced an all-white jury for a crime he said he did not commit. What happened next would reach the Supreme Court and change American justice forever. Louisville, Kentucky. 1981. James Kirkland Batson sat in a Jefferson County courtroom facing second-degree burglary charges. The crime itself was unremarkable. But what happened during jury selection would expose a practice so deeply embedded in American courts that most people never questioned it. The prosecutor used something called peremptory challenges. These allowed attorneys to dismiss potential jurors without giving any reason at all. No explanation required. The prosecutor used 4 of these challenges. And every single one targeted a black juror. By the time selection ended, Batson faced 12 white faces. Not a single black citizen would decide his fate. His attorney objected. The judge overruled it. But Batson refused to let it end there. Here is what you need to understand. This was not new. For over a century, prosecutors across America had used peremptory challenges to systematically exclude black citizens from juries. The practice was an open secret. Everyone in the legal system knew it happened. Defense attorneys complained. Judges shrugged. And the Supreme Court had actually blessed this discrimination in 1965 with a case called Swain v. Alabama. That ruling said defendants had to prove prosecutors had discriminated across multiple cases over years. An almost impossible standard. One trial. Not enough evidence. A pattern in a single courtroom? Insufficient. Prosecutors knew they could strike black jurors with impunity. And they did. For 20 more years, this loophole remained wide open. But something was about to change. Now let me put this in perspective. Think about what this meant for black defendants. You are accused of a crime. The Constitution guarantees you a trial by a jury of your peers. But the prosecutor removes every person who looks like you. And when you object, the court says prove this happens all the time or we cannot help you. How could any defendant gather that evidence? They could not access other trial records. They could not subpoena prosecution strategies. The system protected its own discrimination. Pause 2s, but James Batson had an attorney who saw an opportunity. The Supreme Court's composition had changed. New justices might view this issue differently. It was a gamble. Batson had already been convicted. The Kentucky Supreme Court had rejected his appeal. But his legal team pushed forward anyway. The stakes were not just about one man's freedom. December 1985. The case reaches the United States Supreme Court. Batson's attorneys make a bold argument. They say the Equal Protection Clause of the 14th Amendment should protect defendants from discriminatory jury selection in their own trial. Forget proving years of misconduct. One trial should be enough. The prosecutors from Kentucky push back hard. They argue peremptory challenges must remain absolute. Any restrictions would destroy the entire jury selection system. Attorneys need freedom to make instinctive decisions, they claim. But here is what the prosecution could not explain. If these challenges were truly about instinct and not race, why did the pattern look exactly the same in courtroom after courtroom across the entire country? The justices noticed. And they started asking uncomfortable questions. But here is where the story takes its most important turn. SFX, dramatic sound, Justice Lewis Powell wrote the majority opinion. And what he created would transform American courtrooms forever. Powell established a 3-step test. First, the defendant must show facts suggesting discrimination. Second, if that showing is made, the burden shifts to the prosecutor. Now they must provide a race-neutral explanation for their strikes. Third, the judge decides whether discrimination actually occurred. This was revolutionary. For the first time in American history, prosecutors had to explain themselves. No more hiding behind absolute discretion. No more striking black jurors with a wink and a nod. The vote was 7-2. Even conservative justices joined the majority. They recognized what everyone knew but few would say aloud. The system had been corrupt for generations. The impact was immediate. Across America, defense attorneys started filing Batson challenges. Prosecutors could no longer operate in the shadows. They had to justify every strike they made against minority jurors. And the courts started catching them. In case after case, appellate courts found prosecutors had violated Batson. Convictions were overturned. New trials were ordered. Some prosecutors had explanations so flimsy that judges called them out from the bench. One claimed a black juror looked bored. Another said they did not like how someone answered a question about their children. When forced to explain, the discrimination became visible. Pause twos, but I need you to understand something important. The ruling had limits. Significant limits. And critics argue those limits have allowed discrimination to continue wearing a different mask. Here is the truth the ruling could not fix. Prosecutors learned to game the system. They discovered that almost any explanation satisfied the second step. They struck black jurors for living in certain neighborhoods. For having relatives with criminal records. For wearing particular clothing to court. As long as the reason was not explicitly "I struck them because of race," courts often accepted it. Studies conducted decades after Batson showed disturbing results. In some jurisdictions, prosecutors still struck black jurors at rates far exceeding their strikes of white jurors. The discrimination became coded. More sophisticated. Harder to prove but just as real. SFX, dramatic sound, and yet, Batson remains the law. Every jury selection in every American courtroom now follows its framework. The question is whether the framework does enough. What happened to James Batson himself? His conviction was overturned. Kentucky had to retry him. But his legacy extends far beyond his own case. Today, Batson challenges have been expanded. They now protect against discrimination based on gender. Some courts apply them to ethnicity and religion. The principle he established, that the Constitution forbids using group membership as a reason to exclude jurors, continues to evolve. Every defendant in America now has a tool their predecessors lacked. Is it perfect? No.